Good morning, good afternoon, good evening, wherever you are. This is yet another webinar, open conversations about Interpol abuse, dedicated to the problem of Interpol abuse and defending the rights of individuals on the international wanted list. We're about to start. We have two more panelists who are trying to join us, so please bear with us. Hello, Vanya. Hello, Vanya. We're live. We're just waiting for William to join us, and we'll be able to go on. So we have.
Sorry, I was in the wrong. I entered in the public link.
Yes.
Okay, there is still time for me to brush my hair.
Yes. Yes, sure. We're live. We're waiting for William to join us, so we already have the audience on.
But you're beautiful, Vanya, with or without brushed hair.
Okay.
Beleza.
Okay. William will join us. We're sorry, we're having technical issues. Okay. So that we don't make our audience wait anymore.
Okay, shall I start while you solve the issue?
Yes. So, my co-panelists, I'm Yuri Nemitz. I'm an attorney in Washington, D.C., and the managing member at Nemitz PLLC. My co-panelists today are Vanya Costa-Ramos, a partner at Carlos Pinto de Abreu e Associados in Portugal, Lisbon. She's also the newly elected president of the European Criminal Bar Association. Anna Ermihin, the founder and partner at Ermihin International, and William Joly, the founding partner at WJ Avocat. Today, we're going to talk about Interpol's case law. So what is Interpol case law? The Commission for the Control of Interpol's Files, who has exclusive jurisdiction to adjudicate complaints from individuals challenging government abuse of Interpol's resources, has started publishing its so-called decision excerpts. It started doing it back in 2017, and as of now, the Commission has published over 60 decision excerpts. Of those, 11 were published in 2023, and so far this year, the Commission has published 5 more decisions. The reason they call decision excerpts is because the Commission redacts them, and often redacts them pretty heavily. Nevertheless, they do provide a very important insight into how the Commission interprets the organization's constitution, the rules on data processing, and so forth. Whether they can be called precedents is rather questionable. The Commission has not referred to them as such, but we assume that they are at least highly persuasive, and that's why the Commission publishes it, so that the practitioners and the public in general knows how the Commission interprets the organization's rules. While we were preparing for this webinar, the Interpol General Secretariat published the updated 3rd edition of the Repository of Practice on the application of Articles 2 and 3 of the Interpol Constitution. Article 2, among other things, requires that Interpol act in the spirit of the Universal Declaration of Human Rights, and Article 3 prohibits the organization from engaging in any activities of a political, military, racial, or religious nature. The second previous edition of the repository was issued back in February 2013. We, of course, will not be able to cover all the CCF decisions today, and we will dedicate a separate seminar to the updated repository of practice. Today, we will discuss some of the CCF decision excerpts published, and we will continue covering this topic during our future webinars. With this in mind, I will ask Anna to continue the discussion, and as always, in the end, we'll have a Q&A, so please feel free to ask questions. We'll answer them. Anna, please.
Good afternoon, everybody, and good morning. My name is Anna Ömichen. I'm a lawyer based in Berlin and specialized on international criminal law and European criminal law. And I also publish and lecture on European criminal law issues regularly. My presentation, I have prepared a presentation on a decision, one of the new decisions that were just published of 2023 of the Commission for the Control of Interpol's Files. And I will try to share my screen now. Can you see it?
Yes, we can see it. I think you can maximize the expand it if you want.
You only see parts of it?
No. We see the slides. I mean, if you want to make it full screen, you can do it. You should be able to do it.
Because I made already, like I started.
Oh, okay. Then it should be fine.
But if you don't see the presentation, then it's not showing the right window. Hold on. Just one moment.
Yes, we do see the slides. So if you share it again.
I think now I share the full screen, right?
Okay, great. Yep, that's it.
Yeah, okay. Okay, so I will talk about this green notice decision. So it was a decision that concerned not a red notice, which is a regular notice that seeks the arrest of persons and extradition of persons, but a green notice. And there was one decision on a request regarding a green notice, which I will present to you and outline a bit the practical consequences of that. So what is a green notice? You see Interpol has several types of notices. They have red notices that seek the location and arrest of a person that is wanted by a jurisdiction or an international tribunal with a view to his or her extradition. Then you have yellow notices that are aimed at missing persons. You have blue notices that are aimed to locate, identify, or obtain information on a person of interest in a criminal investigation. And you have green notices that are actually warnings and intelligence, and they concern persons who are to be warned, member states of Interpol, who are to be warned about that person because of that person's potential criminal activities, if that person is considered a possible threat to public safety. As you can see from a publication from Interpol, 12,400 green notices were issued as of December 2023. So it's not a small number, although it's much less than red notices. The legal basis for the green notice is Article 89 of the rules of the processing of data of Interpol. And in that article, the conditions for publishing are provided as follows. The person that is subject to the green notice has to be considered a possible threat to public safety. This conclusion has been drawn from an assessment by a national law enforcement authority or an international entity. This assessment is based on the person's previous criminal convictions or other reasonable grounds. Then there has to be sufficient data provided by the national authority concerning the threat, so that the warning may be relevant. And the green notice also needs to have sufficient identifiers. That means, like with the red notice, you have to have either the family name, the full name, the sex, the date of birth, or the year of birth, physical description, DNA profile, fingerprints, or data contained in the identity documents. Or if you don't have all of that, at least a photograph of good quality along with at least one identifier, such as an alias, the name of one of the parents, or a specific physical characteristic that is not visible on the photograph. When you look at these conditions, you see that there are very vague terms involved, like what is a possible threat to public safety? How do you assess that a person may be considered a possible threat to public safety? Then who is an international entity? Is it an international criminal tribunal? Is it the United Nations? Can it also be like the Human Rights Council, for instance, or the Council of the European Union? So there's a lot margin of discretion in these terms, and even more so in the term of other reasonable grounds. Previous criminal convictions, quite obvious that this may be a reason for a person to consider him or her dangerous, but what are other reasonable grounds that justify such a measure? And then also, what is sufficient data concerning the threat? How much data do you really need to provide to justify that you consider that person a threat to public safety? So these are all terms that are a bit problematic in my view. And when you compare the conditions between red notices and green notices, you see that you have much less conditions for the green notices, actually. So you don't have any minimum criteria as to the seriousness or gravity of the offense. For red notices, it has to be a serious ordinary law crime. It cannot be a regulatory offense. It cannot be an offense related to family or private matters. And it cannot be an offense that is considered controversial, for instance, homosexuality as an offense in some of the countries. So there's no such minimum criteria needed for green notices. Also, there's no penalty threshold that again relates to the potential gravity. For red notices for prosecution, you need at least a maximum punishment of at least 2 years, which is already very low. And for conviction, red notices, you need at least a prison sentence of 6 months. For green notices, you don't need any. It doesn't matter what offense is actually the one for which a conviction was reached. Another requirement is that it has to be, for the red notice, that it has to be of interest for the purposes of international police cooperation. This is also not explicitly written in the article describing the green notices. Just the minimum data are the same, like that you can identify the person, so the name or the DNA or fingerprints, pictures, etc. This is the same in red notices and green notices. But another important requirement for red notices is that there's sufficient judicial data so that you at least have a case summary of the facts of the case, including time and location of the alleged criminal activity. Time and location is very important because that is already needed in order to determine, for instance, if the person had an alibi, if they have a passport that shows they were not in the respective country at the time of the alleged fact. That could be a problem. And for sufficient judicial data also, you don't have such a requirement for green notices. Another important safeguard for red notices is that according to Article 86, they require a legal review before they are actually published. So the CCF, as the General Secretariat of Interpol, is checking every request for a red notice. Though their checkings are not always very profound, but at least they do some summary check and give a legal review of the red notice before publishing it. And this also is not required for green notices. But then there's also some general provisions that are applicable to all notices, and this is the right to access, correct, or delete the data. This concerns all data stored at Interpol's databases, not only red notices. And it has to be for the purpose of international police cooperation in a more general matter. It is provided in the rules for the processing of data as well. So the data must be relevant and not excessive in relation to their purpose. It has to be compliant with the Universal Declaration of Human Rights, and Yuri will speak about this in more detail, because now we have some more information from Interpol what they understand under those provisions. And the same regards Article 3 of the Constitution, the prohibition to use Interpol for political, military, religious, or racial motives. So the problems I think you have already identified by the comparison between red notice and green notices. The green notice is a merely preventive measure. There's no minimum gravity required, and there's no judicial data required, so there's no possibility to even make a plausibility check or a compliance check of the green notice. If you see one, you cannot check if it is for inconsistencies, you cannot check if it may be illegal, if it might not meet dual criminality requirements, etc. And there's no prior review by the CCF. Now I come to the recent decision, and this is, to my knowledge, the first decision of CCF that has been published on a green notice, but please correct me if you know about another one. For me, I haven't read about such a decision yet. That's why I wanted to present it to you. And the facts of the case are as follows. You have an applicant from A, from country E. CCF anonymizes this totally, so we have no clue from which country applicant A is. And he lodged, or she lodged, a deletion request in 2022. The Commission found the request admissible. We don't know if the Commission met the deadline of 3 months to find admissibility or not, because we don't know the exact date. And the Commission informed A about it. The Commission consulted with two source countries, C and D. C was a country that actually issued a diffusion for arrest in view of extradition. And D issued a green notice because of his conviction and charges in D, but we do not know what conviction and what charges he had faced in the country D. The applicant submitted that he or she had served the sentence fully in D, and that the alleged acts dated back 16 years. This was his argument to say that the green notice should be deleted. The NCB from country D confirmed that he had served the sentence and reported that A was a member of a gang and that he had been convicted of 2 crimes, but we do not know which 2 crimes. And we do not know what kind of gang they refer to. It confirmed that the verdict had been issued and executed. So the country names, the specific dates, the offenses, and the charges were all redacted in the published decision, so we do not know any details on that. And the Commission, on the basis of this information plus more, considered that the NCB of D gave explanations about A's membership in a gang, whatever gang, and that his previous conviction was related to redacted. The NCB considered that A was to be considered a threat to public safety, and that other Interpol members should be warned as he was a dangerous suspect. This is the finding of the Commission. The Commission actually found him to be a dangerous suspect. We do not know of what offense he was actually suspected of, because he had already been convicted and served his sentence fully. But we also know that there was another diffusion against him from this country C. So that may have been in relation to this suspicion. But we do not know any details on that. We also do not know what gravity such a suspicion had. And on the basis of these two arguments, the CCF found that the NCB statement provides sufficient elements and data to justify that the applicant represents a threat to public safety and that a warning is relevant. Regarding the diffusion from C, in that context, the applicant had argued that the charges against him were dropped because of the statute of limitations. And based on this argument, the NCB of C actually confirmed that the charges had been dropped and requested also the diffusion to be deleted, and therefore the diffusion was deleted, and hence the Commission said that A's claims and arguments in relation to the diffusion do no longer apply. And as a consequence, all the data challenged was compliant, not compliant with Interpol's rules. So the practical consequences of a green notice are, however, severe, or can be severe, in spite of this very, very little requisites that you need. You may face entry bans when you travel, you may face travel bans, financial measures. Countries might adopt freezing of assets, arrests. People could also arrest you based on a green notice. Depends on how they assess this threat, and you might be questioned. It also might affect third parties who are traveling with you, for instance, or who are somehow in contact with you and are considered suspicious because you are a dangerous suspect based on the green notice. And all that is based on mere police information that is not subject to any prior legality review, and that does not need to meet any threshold of proportionality or gravity. And this is something very serious in my point of view. So it can have severe consequences while there's very few legal requirements for this to happen. And that's actually it. I'm done for today and happy to discuss this.
I think that I just want to add, I think that the lesson from that case is that even after you serve your sentence, you can still end up in Interpol database because you present some threat to the public, and it's much harder to dispute a green notice as opposed to a red notice sometimes because the requirements are so vague. But we'll discuss it further during Q&A. Vanya, would you like to continue?
Just give me a few seconds just to project the PowerPoint. Okay, to see if this works. Sorry, I did the wrong. Okay. Do you see my? No, you don't see anything.
No, I will receive a request when you share your screen,
okay.
And then I'll approve it right away.
Because it somehow doesn't show on the options. I don't see my PowerPoint on the options. Just window.
If you click on share screen,
Okay.
there is a button right next to the camera icon.
Yeah.
Yeah, if you click on it.
Now the only problem is that it doesn't show somehow my PowerPoint. Let me just open it again as an option. Otherwise, I'll show it in a different manner, and I hope it works.
Vanya, I did it secondly by starting the presentation first and then sharing the screen with the right window. Where the
Okay.
presentation had already opened.
Then I'm gonna do exactly the same and hope that this works. Okay. Okay. So, okay. I just have to open a different screen. I'm sorry for this technical glitch. I think I need two screens to be able to do this properly. Okay, so now it should work. Okay, yeah, I hope this will work for you. Okay, so do you see? I'm asking you to share. Yeah, it doesn't show up, so I'm gonna try to use something different. Let me see if this works. So you'll have to bear with me because this will be the first time that I'm using this.
It's so there is a button. If you can, if
Yeah.
we can figure it out, I suggest we just maybe if you can read your presentation. There is a button underneath the screen in Restream. Yeah, I think it should be okay now. Got it. Yep, we can see it.
I just sorry, this is just like a different app. But
It's working. It's working.
Yeah. Let me just go up. Yeah, sorry. So apologies for this.
No problem. No problem.
This glitch. I'm going to address two decisions. So we discussed and we selected a few interesting decisions from 2023, 2024, and I would like to present you with two decisions that address the same issue. And the issue is the role of extradition refusals in proceedings before the CCF. So for those who may not be acquainted with the procedures, of course, when you make submissions to the CCF, you will try to, you will make your arguments based on, obviously, on certain facts and points that address the shortcomings of the data processing by Interpol. And obviously, you need to use some evidence or legal arguments also and evidence. And the question that these decisions address, among others, is what is the role of an extradition refusal in a state party that is normally a different one from the one that is, of course, requesting for the issuance of the red notice. Why do I use the word mutual recognition, but between, not stricto sensu, for those of you who may be in the system of the European Union or in Europe, you have heard of the principle of mutual recognition. Under EU law, this implies that member states should give or treat decisions by other member states as if they were their own. Let's say this is the general principle. There is exceptions to it. It's not an absolute principle. But I use this in a broader sense because, of course, in international law, you can also use this concept wider. And this is, let's say, used here rather as a concept to state like how, to which extent in the international scenario, certain states or certain entities like the CCF should recognize and give some weight to the decisions by other states or entities. So what does the CCF say? And let me try to change. Do you see? Yeah, this is quite clear now. So there are two decisions. First, decision number 2 of 2023. And in this case, there was a national of a member state. Again, as Anna outlined, we never know which state, we may speculate, but a citizen of state D is the subject of a red notice issued at the request of the NCB of state CCC, so a different member state. And one of the arguments that he brings before the CCF is that actually his extradition for the same facts, for the same red notice, has already been denied by state EEE. What was the reason and why did EEE refuse extradition? Based on two legal grounds. The first one was nebis in idem principle, but with a particularity, because in this case, the decision was not taken by the state EEE, it had been taken by a different state. But I'm guessing this is a European Union state. This state EEE gave that decision the same value as if it were its own decision, because within the European Union, decisions by other member states will have the same value. So if you've been prosecuted in a member state, you can no longer be prosecuted in another member state for the same facts. This is very different from the US, for example, and of course, it is not a general principle in international law. Not all states recognize this cross-border nebis in idem. Second grounds were statute of limitations due to the passage of time. So under EEE law, the person could no longer be extradited due to the statute of limitations. What did the CCF find? The CCF found that, yes, extradition processes are quite complex. They involve different types of laws, national law, international law, extradition treaties, human rights treaties, and other international obligations. And there are different refusal grounds established in all of these instruments. They can be based on more procedural elements or substantive elements, and they can be based on the features of the criminal case underlying extradition, or also in the situation of the individual. Let's say, to give an example, of course, it could be the fact that a certain case, as Anna mentioned, is for a crime of being homosexual, for example. So these proceedings would not be criminalized in this crime would not exist in many member states, and therefore it would affect extradition. On the other hand, it can be that, for example, individual has a mental health disorder, a serious one, and cannot be extradited because he would be subject to ill treatment or a serious risk to health or even life were he to be extradited. What did the CCF say, looking at the decision of this member state? Well, the decision was based on nebis in idem and on the statute of limitations. So the CCF considered that this would not affect the validity of a red notice. Why? Because statute of limitation is something defined in domestic law. The rules are different in the different countries. And therefore, the fact that EEE can no longer prosecute and also not extradite the person would not preclude the right of CCC to still seek extradition, and the person could still be extradited from other member states. As for nebis in idem, the CCF decided, there is another section of the decision only about nebis in idem, but the CCF recalls that, well, there is no international jus cogens rule that bars cross-border nebis in idem. So for the purposes of the assessment by the CCF, cross-border nebis in idem would only apply if there had been a transfer of the criminal proceedings by the state that is now seeking the red notice to the state that has already issued a final decision. As it was not the case, they also ruled that this would be it would not be relevant. So finally, they did well. There is some other considerations that are not as important for our topic now, but they upheld the red notice, subject to adding information on Interpol system that there had been a refusal to extradite due to statute of limitations and nebis in idem. We will see why this is relevant still, to add this flag to the data, because some countries may also recognize this cross-border nebis in idem, and therefore this may be very important for the individual. Second decision, and I can already perhaps be a little bit of a spoiler and say what is the outcome. The outcome was that it was different. So they did, the CCF did conclude that there was a breach of the rules on processing of data and also on Article 2, etc. But the second case was about also a person, national of a state, we don't know which one, state EEE, and he was subject of a red notice published at the request of CCC. So again, this person argued, among others, that his extradition to CCC had already been denied by another state, DDD. And why? Because the courts of this state found that there was a risk of violation of his human rights, and also because he had a protective status, a refugee status in that member state. This was analyzed by the CCF. Why the applicant argued, of course, about that there was a risk of violation of, being subject to torture, also on account of both violence and the prison conditions, violations of multiple defense rights, and also a general situation of violation of human rights in the country. He added different types of evidence, notably also some witness statements and reports on these issues. But notably, he argued that the courts of state DDD had already assessed this, and they had concluded that there was actually a risk for his human rights, and he could not be extradited due to that risk. Of course, as usual, the CCF asks for the provision of information from the national central bureaus of the relevant member states. So state DDD provided information. They confirmed that extradition had been refused, and they also explained, they provided a copy, and they explained exactly that these were the reasons behind the refusal to extradite. What was the, of course, oh, sorry, this did not go down. So the CCF analyzed the different aspects of the decision, but it did give great weight to the fact that the courts of DDD had already assessed the risk of a violation of his human rights. And of course, then these risks would be the same risks that Interpol would have to, the CCF, sorry, would have to analyze under Article 2 and the spirit of the Universal Declaration on Human Rights. And therefore, of course, the court also cites that, the CCF cites that the court used different expert reports, different NGO reports, different reports from international governmental organizations that corroborated these risks. And of course, they also gave some weight to the refugee status. There was a technical point here because the refugee status was in respect of the state of nationality, but the state seeking extradition was not that member state, it was a different state. So the applicant had sought to argue that the principle of non-refoulement would also apply in respect of that other member state, that there was a risk of re-extradition. The CCF considered that stricto sensu, the refugee policy would not apply because it would only apply in respect of the state of nationality. However, it did consider, in addition to the refusal to extradite in DDD, that the fact that the applicant did have a refugee status due to the risk of being subject to violations of his human rights. And also there was some doubts about the clear involvement of the applicant in the criminal activity, but the CCF had said at the outset they will not enter into this topic because there are many doubts and it is not dispositive per se, but they do note that these were also, let's say, aggravating circumstances, confirming their decision. So outcome was that the data concerning the applicant was considered not to be compliant with Interpol rules and should be deleted from the Interpol files. Of course, I had not time to put it here, but if you look at the decision, you will find also it's quite useful the list of the provisions that were applied in greater detail that you can use for your own cases. Just as a finishing, like to leave some teaser, and I think we will go into this in the discussion later on. But Yuri referred that I was recently elected as the chairperson of the European Criminal Bar Association. Thank you so much for referring to that. For those who do not know, the ECBA, it's an organization of defense lawyers from all across the Council of Europe member states. There are also colleagues from outside of Europe that joined the organization, and it is devoted to two bulks. One is, of course, the exchange of professional practice and knowledge, and the other bulk is also advocacy intervention at let's say, judicial and political level. We launched a statement in 2022 precisely about this. What happens when one state refuses extradition? What should happen? Should the person still, stay at risk of traveling and being rearrested in different countries? We focus on the European Union because in the European Union, the cross-border elements of fundamental rights are more developed than elsewhere. And we argue that, well, there should be a way that these decisions should actually have effects in other states. And we proposed a specific systematic, and I think I'm not going to describe it now because it's going to be more interesting to go into these points after William has presented his case, and then we can discuss about this. But it will be nice to see how this actually integrates with the CCF decisions that I've just told you about. Thank you.
Thank you, Vanya. Thank you very much. William, your turn.
Thanks, mate. Thanks for having me again on the show. Vanya, I'm sure no one does not know what ECBA is. And if ever anyone still somewhere in the world did not know, since you are chair, I'm sure this will never again happen. So really quickly, not to be boring, because I have another section on sanctions that I really want to leave time for discussion, because I think it's actually a topic that has not been discussed much, or maybe never actually, in connection with Interpol. I'm handing over to Yuri, who's our worldwide Interpol specialist here. But the interplay between Interpol and sanctions, and that is an absolutely fascinating area that I must say I'm just opening myself. And so I'd like to have some time, but just a quick word on European Court of Justice decision that fits in quite well with what Vanya just presented, which is a very recent decision. I can share it afterwards, and I posted on my LinkedIn post, I think the date of the decision, maybe the reference. It's a 29th of July 2024 decision, which was delivered by the European Court of Justice on a preliminary request for ruling. So really briefly, when a national court in a member state of the European Union considers that there's a question of interpretation of a European regulation, then it can hand over, and often the defense asks them to do so, but the courts can do it themselves, picks up its phone, rings the European Court of Justice and say, "Hi guys, we've got this question, what do you think about it?" So this is the case, which is the one of an individual who was arrested in France, and he was wanted by Romania. France, for once, refused to surrender this guy, considering that there was a risk of infringement of one of his fundamental rights, which was the one to a fair trial, because they considered that these judges in this Romanian court did not meet the test in terms of their oath, which was quite interesting, and that there was no guarantees that these sitting judges were proper judges, independent, etc. This guy was then released, and he traveled again, and a little later, 6 months after that, he was arrested again in Malta for the reasons that Vanya touched upon, which is that in our wonderful EU territory, if you are arrested in one member state on an EAW, which is a European warrant of arrest, then you can perfectly well be arrested again because you still remain in the Schengen system, which is the equivalent of the Interpol system. And you actually can still be in the Interpol system if CCF has not taken you out. So this guy is arrested in Malta. And Romania again says, okay, hand him over. And then it is a refusal from the Maltese authorities to hand him over, not for the same reason, but this time in regards to risk of infringement of his fundamental rights in prison on grounds of Article 3 equivalent of European Court of Human Rights, meaning that he will be ill-treated in jail, etc., and no sufficient guarantees were given by Romania. So the Court of Appeal in Romania was really cross about this second defeat and handed over a question to the European Court of Justice saying, okay, we have a first decision, then we have a second decision, we issued another warrant of arrest, we want him to be surrendered, and how do we need to read European regulation in regards to what is happening? And for what is of interest for us, obviously for all our colleagues interested in European questions about what is binding, not binding, half binding, or not binding but being binding, which is roughly what the court said, which is that it's not binding, but the member state must take the former decision into consideration. So it's not binding, but it's binding. So that was a really European answer to the question, which I quite like. And this is all about our white paper that Vanya maybe will give you a bit more details about, but obviously that you can go and get on the ECBA website, etc. And that is ongoing lobbying, but really interesting stuff. So for what concerns our Interpol practitioners here is that the European Court said something about Interpol CCF removal decisions, which is not so usual. We checked, and I might be wrong, but we only found a couple of decisions where in sanction-related matters, the European Court of Justice, which is competent to deal with, has jurisdiction to delist individuals who are sanctioned by the EU. The court sometimes made statements about arguments from the Council of Europe, which is the body which decides to sanction someone or an entity, and all the defense saying, oh, look, this guy is in Interpol. He's got a red notice, meaning he's a real naughty one. This Russian chap is in Interpol. Or this, I don't know, Ukrainian former politician is in Interpol, wanted for money laundering in Ukraine. I don't know. Or the defense saying, look, he was on Interpol, but he was taken out. He's a good guy. And the court usually says, we're not really interested. Sanction-wise, Interpol, CCF is not part of the criteria to be sanctioned or delisted, so we're not really interested. But in this decision, there's a very straightforward assessment with an indication given that CCF removal decision, if was taken, and in the case of this chap wanted by Romania, there was a success at CCF level, the Court of Justice of Europe said this is an element that can be taken into consideration by the member state, which is the one who is going to decide to surrender or not. It is not binding, of course, because even a member state decision not to extradite, as Vanya explained, is not binding. And as I confirmed, is not binding, but is binding. But CCF is not binding, but it exists and it can be taken into account. Would the member state consider that what is in the decision is useful for what they have to make their mind upon? So this is a recognition from the European Court of Justice, which I must say is a quality court. I don't know what Vanya will say, but I must say that I've been there once in a while these past 2 years and a half. And compared to French courts, it's actually quite a high level place to go to, and I must say that usually the decisions are quite well drafted, and the reasonings are not completely stupid. So that is for the ECJ. Maybe a word back to you, Vanya, and then I'll have a go on the sanction section.
Yeah, thank you, William. Just a quick one. I think this is really, really relevant, and we need to use these arguments more. But of course, they are not absolute. I mean, it all depends on why extradition has been refused. And we have now already, so we basically, the statement proposes a different, like 3 types of refusal grounds. We try to propose some kind of systematic approach, and some of them would not generate a refusal to, of the a recognition of the refusal to extradite. Some of them would, and they would be of permanent nature. Let's say if you've already been tried in a state and you can no longer be prosecuted for those offenses or those facts, then this is a permanent refusal ground. Some others could be temporary refusal grounds. Let's imagine the issue was the risk of torture due to degrading prison conditions, and that may improve over time, or even a political situation in a certain country. So we propose this systematic. If we look at the Interpol decisions, it's interesting at the CCF decisions to see how they were different in the 2 cases, and why. Because they consider that one of the national decisions was based on, let's say, universally recognized reasons on why a person could not be extradited. So if those reasons subsist, it means that the red notice would in the end not have a purpose, because in the end the person could not be extradited. So they gave weight, as William says, it's not automatic, but they gave a particular weight to that assessment by the court of that state. In the other case, they put nebis in idem and statute of limitations in the, let's say, domestic and procedural reasons for refusal. We could have a nice discussion about, especially about nebis in idem. Statute of limitations is more complicated, whether actually we should agree with this position, but we don't have time today. Perhaps just to conclude, to say that I think we are looking at the different member states and trying to find decisions that outline how this approach that we are suggesting makes sense. And I'm happy to say that, of course, some countries do already have adopted similar approaches. One example is Portugal, where we've managed to have a decision by one of our higher courts that has recognized a Spanish decision refusing to extradite to Angola. And this means that the person can now move between Spain and Portugal, at least, without any risk. And that was based on the violation of right to liberty and also right to a fair trial, due to the lack of judicial oversight over the warrant. And also we found some decisions from Spain and Italy, also recognizing when there is refugee status or political persecution or risk of torture. So I would really like to invite all of you who are out there listening now or at any moment later, if you have any cases, be it before the CCF, be it before courts of your states, be it before international organizations or courts, please reach out to us, because we're updating the statement and looking for good case examples to show that also courts in member states agree that the approach to decisions to refuse extradition should be widened. The effect of these decisions should very often be, go beyond the borders and be recognized by other authorities. This also saves time and money. It's not only about, of course, of what we care most, which is the protection of the individual's rights, but actually it also saves resources to those other states that don't need to enter again into the assessment of the violation of these fundamental rights. They can rely and trust on other states, just like they trust those other states, to arrest someone and perhaps extradite them. They can also trust when they have decided otherwise.
That is what I call a chair, the CBA.
William, do you want to talk about sanctions?
Yeah, just one word to add to what Vanya said, and then you'll tell me, Yuri, how much time I've got on sanctions.
You've got all the time you need. No worries.
Okay, cool. That's nice. I'm not used to hear that kind of indication, but I won't be more than 5 hours. So Vanya, just maybe to add for all our Interpol listeners, what is really interesting within the European Union is that we consider that we have this mutual trust territory where we can surrender people without looking too much into the cases. This is all about EAWs, and that we have no borders, and that we kind of, all walk together criminal-wise. The thing is, we do not have what we have with Interpol that we are criticizing a lot, and we are right to do so. But at Interpol, there's a CCF. Within Europe, there's nothing. That means that what Vanya was touching upon, which is you get a guy who is not surrendered by Spain to Angola or by Portugal, and then he wants to go to Spain, he can't. If he goes there, he can get arrested again. And this is the example from my guy arrested in France and Malta. And that can go on in every single country of the Schengen territory, which is roughly Europe plus 1 or 2 countries. And we don't have a mechanism where we can write to someone and say, hi guys, we got this case, please take him out of the Schengen system, which is the equivalent of Interpol system. And if we do that, they will answer that the only authority that can decide to withdraw data from the system is the owner of the data, which is roughly the NCB equivalent, which is the Romanian state. And obviously Romania is not going to pull it out because they want the guy. So the guy stays stuck, and there is no solution, which is interesting when, you see that we consider we've got this mutual trust territory. There's no mechanism equivalent to CCF, and this is also something we're trying to work on, and we'll try to connect all Vanya's ECBA job, which is also actually a bit of ours also with all our French and European colleagues, but to connect it with a mechanism that will affect SIS, Schengen Information System. So on sanctions. So this is the book that you guys need to get, which is this repository of practice that Yuri touched upon, which is now with Article 2 and 3, which is progress, because before there was only Article 3, which is the non-political requirement for Interpol and the neutrality principle. Article 2 is that Interpol must act in the spirit of Universal Declaration of Human Rights, which is very interesting, but violation of sanction section, which is here, and this is when you check it out from page 70 onwards, dealing with Article 3 issues. So we're going to discuss connection between sanction regimes, Interpol notices, which we all know can only target individuals. Maybe one day there will be legal entities under another kind of system of information. But for the moment, we're talking about individuals because sanctions often also target legal entities, meaning companies. But there are a lot of situations where individuals are concerned by requests for arrest or other kind of notices or diffusions in connection with sanctions. And I was actually quite surprised because I think, Yuri, that all these examples that are given page 73, 74, 75, 76, 77, there are 22 cases, which obviously corresponds to cases that the CCF dealt with. And I was quite surprised that there were as many cases where directly sanction connected matters were handed over to CCF, with quite a couple of non-compliance decisions with really interesting reasoning. So I won't go through them because they're actually quite complex, and you guys really need to read them carefully to understand, you know, what they're made of and about. But just to give you maybe a general flyover of what is at stake, and maybe give you the desire to go and read in more detail. I think maybe to start, we can follow the division that the repository carries out in regards to what is binding meaning concerned by risk of violation of Article 3, meaning political motivation, violation of neutrality principle that Interpol must comply with, depending on which sanction regimes. And immediately we grasp that when we talk Interpol, we often talk about where are we in the field of law, when are we in the field of politics, geopolitics, and I guess this is why we like Interpol. So with sanctions, it's the same. Sanctions are a bit like Interpol. And the funny part is that sanctions, often per definition, are political measures. Sanctions are not, they come to be legal at one point because, for example, in Europe, there's council regulation, but who is sanctioned is decided by the Council of Europe, which is composed by all European member states, and they vote and they decide to sanction Mr. Abramovich, or they decide to sanction Mr. Putin, or they decide to sanction this guy from Venezuela. And that is a political decision. Then it becomes legal because there's a regulation and you can challenge it, but it is at the beginning a political decision. And this is where it starts to become really interesting when it connects with Interpol, because obviously, let's say, to take an example that I had, the USA issues a red notice against a Lebanese citizen who happens to be close to some Shia politicians. And we know that the US are not super friendly with the Shia community in regards to what they claim are their connections with Iran. And this guy ends up with a red notice wanted for terrorism and money laundering in relation with Hezbollah activities, etc. And this guy gets arrested in France. And in the course of his extradition process, but also in the course of a possible CCF removal application, I won't comment on this because it's ongoing, but I am saying, guys, you've got an issue. I mean, he's wanted for what the USA claim is ordinary crime, and the neutrality principle within Article 3 requests that Interpol only deals with ordinary crime, not political matters. And the US say, but look, this guy's a terrorist. And I'm saying, guys, maybe you consider that doing business with Lebanese Shia companies and Iran is terrorism, but Hezbollah in its political branch in Europe is not considered as a terrorist organization. So what do you consider Interpol? And this is where it becomes interesting and sometimes complicated, because we also have in France and in Europe a blocking statute, which is that at one point, European Union issued a regulation saying that in regards to certain extraterritorial regulations from the US, for example, EU companies, entities, individuals must not comply with these laws. And if BNP, French National Bank, was sanctioned 9 billion fine by the US, it did not comply with EU regulation blocking statute, but it did pay the fine because it could not be disconnected from dollar in the world finance universe. but we have a blocking statute, so we're abiding EU law. We consider that we didn't commit any offence. What will Interpol say? Another case would be, and that is the CADI, very well-known European Court of Justice decision, which was about fundamental rights and UN sanctions and how they were transposed in EU. What does Interpol say if someone is wanted in regards to sanctions by the UN? Because in many countries in the world, violation of UN, United Nations sanctions in regards to non-proliferation of weapons of massive destruction, they'll use goods. Are these political? And as many countries consider the violation of sanctions as a criminal offense, you can have a country issuing a red notice for that. Or you can also, because there's within Interpol a special kind of notice which is destined for the execution of UN sanctioned individuals. What does Interpol say about that? Is that political? So this division that I was speaking about is that in this repository of practice, it is said that UN sanctions, on the face of them, are considered to be compliant with Article 3. Because UN sanctions are United Nations sanctions, and this is the world. So there is a presumption that it's okay, and that it's not political, but if it is political, it's the political position that is agreed by the entire humanity, so that it's okay, which is quite funny, because at the end of the day, when you look at how sanctions are issued by the United Nations, they are issued by a vote, not of the General Assembly, but of the Security Council, which is composed of the US, China, Russia, France, and the UK. So this is the worldwide compliance with Article 3 seen from the Interpol point of view, knowing that there is a caveat, which is that this is a presumption, and I guess you could give it a shot if you could prove that despite this being UN sanctioned, that there are specificities that would bring the CCF to look at it otherwise. Second layer of risk from the Interpol point of view is regional or is sanctions under multilateral treaties, which is just under UN sanctions. So these are all the sanctions which are connected with customary international law or multilateral treaties, such as non-proliferation of weapons of mass destruction, and there are another couple of treaties. For these, it is also said that it is considered to be better than the third category, which is regional or unilateral sanctions, and I'll finish with that one. And that it is possible to look into each case to see if there is a specific risk of non-compliance with Article 3. And just a funny example on that one that I can speak about, because it is absolutely public. I'm part of the Defence International team trying to help Paul Watson, the whale defender who is now in prison in Denmark or in Greenland, on the face of a red notice issued by Japan that we consider is a politically motivated red notice. And in that case, there happens also to be a treaty, which is an international treaty from which Japan has withdrawn, which bans fishing whales. And there could be an interesting discussion to know whether we could, if there were sanctions that Japan was considered not applicable against them. There could be a discussion to know whether it could be opposed to a country that was issuing a red notice in regards to sanctions, or on the other side, that was questioned by having arrested someone on the face of a red notice issued by a country which is not part of a treaty connected to these sanctions. There could be a discussion before the CCF to know, would a country not part of that treaty be bound by the effects of this treaty via the red notice on the situation that would be taken by another NCB that would possibly be asked to say what they think by the CCF. The third and last layer, and then I'm done, is regional or unilateral sanctions. And this is quite interesting to see that EU sanction regimes are considered to be regional and are treated the same way as unilateral sanction regimes. And some unilateral sanction regimes are very well known in the world, of course, the US coming first, but there are also other sanction regimes, such as the French one, and there's also a sanction regime in Ukraine, where a very large number of individuals, Russian-connected, is sanctioned, which have not been sanctioned in the EU. And the practice notebook considers that in the situation of regional or unilateral sanctions and notices connected, it is the predominance test which has to be carried out, the predominance test being the one that is usually applied when the political motivation argument is raised in non-sanction connected cases. So quite a lot of situations with complex matters that are brought to the desk of the CCF, and apparently quite some decisions of non-compliance that have been recognized by the CCF, with probably as a consequence the removal of the notices or diffusions from the Interpol system, and for these individuals the possibility to travel again, at least outside of Europe. And that is my conclusion, because I also have a case which is public, where we have successfully represented a client before the European Court of Justice, who was recently delisted. The Court of Justice decided that he should never have been listed from day one. Decisions from the European Court of Justice in matters of sanction, delisting, are retroactive. That means that we can seek compensation, but this individual is being prosecuted in a European member state where he holds assets, because it is claimed that when he was sanctioned, he didn't report them. And that is in itself a criminal offense. And we are now telling the prosecutors of that country, you can't go after him for not having reporting assets on the face of a decision to list him that has now been considered from day one unlawful. And we're having a fight about that. And in regards to this ongoing prosecution, would our client end up being sanctioned, criminally speaking, meaning receiving a sentence by a criminal court, which is possible? He could end up with a red notice or with a European arrest warrant issued in regards to him not complying with European sanction regime, and we could end up addressing the CCF, a request to remove the red notice because of the political motivation of the notice and bringing in ECJ favorable decisions. So these are matters that can seem maybe a bit far-fetched if you do not do sanction work, but keep your ears and eyes open, because criminal prosecutions in regards to sanction violations are growing, more and more consistent all around Europe, for what I know. And for all of our European Interpol practitioners, they might be a couple of cases coming in the next months and years.
Thank you, William. Thank you very much. A very, very thorough analysis. I have a couple of questions, I guess, and things that I'd like to point out. But first, I'll ask Anna and Vanya if they have anything to add, and also to our audience. Feel free to post your questions in the chat. We'll gladly answer them. Let's start our Q&A, and then I guess we can discuss among us, the panelists. Ask each other questions as well. So Anya and Vanya, do you guys have anything to add? Anna and Vanya, do you have anything to add to what William has said, or maybe to what you've said? Okay.
I think I'd give the floor to Anna if she wants to intervene. At this stage, no comments. I think it is very clear. So just looking forward.
No.
Very clear, comprehensive.
Okay, William. So this is a question for me. In that decision that you just covered so thoroughly of the European Court of Justice, do you think that, so the court compares a CCF decision with a report by the Working Group on Arbitrary Detention under the aegis of the United Nations Human Rights Council. Sort of something like a third-party opinion, even though it was by an intergovernmental organization. Do you think that CCF would give the European Court of Justice, a European Court of Justice decision, more deference than the European Court of Justice has given to CCF?
Yeah, that's a good question. Listen, I mean, I'm waiting to see what happens on a couple of ongoing decisions I'm expecting from CCF. But I must say, and I also, and I think you guys also have in mind who is now sitting in the CCF sessions. For sure, we've got two French guys who have a very strong human rights background. One is special rapporteur before the United Nations dealing actually with environment matters. Another one who is a French chap who we know has a very strong human rights background. And I must say that I met him at a conference in London and had a chat with him, and he really is a good guy. Obviously we didn't discuss any specific case, but I mean we had a real good chat about human rights and so on. I also must say that on a couple of recent requests, I received very quick answers, and on one case, before even sending a request for suspension of the notice, pending examination of my removal application, only on a request for data, I received an indication that they had suspended the notice, only on responding that there was data in the system. And I must say that I had never seen that. On another case, we requested suspension. I must say that I had not very often got suspensions, except in cases where really I consider it was outrageous. And on a kind of financial crime connected case, not high profile, I requested suspension. I got it within 3 weeks of sending the request for removal. So I don't want to be too kind of optimistic, but I mean, my feeling is that things are at the moment going somehow in the right direction. Maybe it's only temporary. Maybe I just got lucky on one or two occasions. But to answer your question, listen, I mean, ECJ, as I said, I consider, I mean, we're not always happy with their decisions, of course, but it's, I consider it's one of the higher level. I mean, it's for me, I'm happy to hear what Vanya has to say, but I mean, it is for me the best quality court in Europe, with maybe the UK courts in extradition matters, which I must say are very, I mean, for me are excellent courts. So yeah, I mean, I would say point for the ECJ first, of course. But yeah, maybe CCF is going to continue going in the right direction.
I think that CCF gives. I think that the kind of the obvious irony of this case is that just from my experience and in general, what CCF writes in its decisions when it cites, including European Court of Justice, European Court of Human Rights. I think that CCF gives them a lot of deference. And from this decision, the European Court of Justice decision, it seems like they are not, the European Court of Justice isn't ready to give CCF as much deference at all. That's just my
No, but they did right. I mean, it's not worth nothing. Which I mean, hopefully,
right.
Which I mean, for the ECJ is kind of when they recognise you exist. I mean, it's not completely void.
Right. No. It's not. I agree. But I think that in general, the general direction that the ICG has taken, and I believe that the WS versus Germany, the decision that was rendered several years ago, I believe it was also the European Court of Justice decision. I think that the general approach is that you can continue processing information even if it's non-compliant, but just take it into consideration when you make the final decision, whatever the decision, whether to extradite a person, whether to prolong the detention and so forth. And Vanya, I'm sorry, William asked, thought you'd add something. If you want to add, please.
Whether the Court of Justice is the best court dealing with extradition, I don't know. I'm always reluctant to use the terms best.
No, but I mean,
rightly so.
I tend to think that judges, their quality, and professional individuals. I tend to quite like the ECJ. But
I think that the issue is that they look into the issues in detail, and I think
that's what I mean.
In other areas, they are not as convincing, but in these areas,
no, I agree. But
they are.
I tend to think that the reasonings are quite, thorough, and even on sanctioned cases. I mean, sometimes I don't agree, and even the quality of the debates and.
It's different. It's different issues, of course. So I think the quality of the debates is very high. I mean, in extradition cases, you don't really have a very well-reasoned decision, but you do have the position of the Advocate General, which is, let's say, setting the scene and also giving more doctrinal basis to the court's decisions. And of course, I think the thing is that whatever. I think if everyone has a case that touches, let's say, certain areas, those areas are the ones that the court is like more progressive looking at. And those are the areas that touch upon, yes, freedom of movement, whether you can use your rights to move freely in the European space and, not to have to also be extradited elsewhere where you would be protected in that space. And the other areas is, of course, violations of certain fundamental rights. And one very interesting right, which is a little bit like a never-ending open, like Pandora box, which is the right to an effective remedy and the right to have effective remedies and to be able to actually challenge your case. That is, let's say, Article 47 of the Charter and 19 of the treaty. This is a bit if people who are more like acquainted to the US law would look at the Constitution a bit like the due process clause, where you can like start putting a lot of fundamental issues. And there I do agree with William that it is the forum where you can discuss these issues at very high level of quality and in a productive method.
And to give you another example, Vanya, which is often I consider that I need to go to the European Court of Justice on a preliminary request for ruling because the French case law is just so bad.
Yeah.
To give an example that is connected with our Interpol work, child abduction from one of the parents who decides to leave with one of the kids abroad in violation of a decision from a French court because there are allegations of sexual, violence by the dad or by the mother. It's not final, and one of the parents freaks out, goes to Morocco or goes to India. I have a couple of cases like that where I also have Interpol applications connected, yellow notice, red notice for child abduction. So that's Interpol work too. And there's a decision from ECJ that has been rendered in a case where a European Union member state was concerned by this situation, and the kid was, I think, taken to India. And there's a very useful ruling which says that under the International Le Hague Convention, even if it is true that in the first place there was a violation of a French order, that if the child has settled in India and if it is where the child has now got his best interest, even if it is 3 or 4 years later, that it must be considered that this is where the jurisdiction now will be and not where it was in the first place, even if there is at one point a violation of an EU member state court order. And that is something that I'm going to use in a French case, because the French case law considers, once you've got your decision from Morocco or India saying, okay, now the kid is in this country, has been for 4 years, and if you want to ask something, you need to ask it to the Moroccan judge. And when I have a court decision saying so, on the grounds of an application forwarded in by the prosecutor of any of the two countries saying it's now Morocco, it's not France anymore, French case law, 100% is fussy because the judges do not accept that their order was violated 5 years ago, and they say that they will not consider the Moroccan decision as being binding. And this is a violation of international law. And my only hope to get a French judge to bend his usual case law, I think, is to use this European Court of Justice decision that is going to say, okay, you've got international or European law and you have to apply it. And it's binding in your country. And often member states do not want to bend. And it is the European Court that helps us do it. And that helps us with Interpol, because if I get a favorable decision from the Court of Justice, then, as you said, Yuriv, CCF tends to think, oh, okay, ECJ made a decision saying that, now the child was located and this is where the child now had his, best interest. For CCF, that's not nothing.
That's exactly so. And again, I think CCF gives much more deference to even national courts. Then again, national courts give CCF or international courts like ECJ do. And in this same regard, I wanted to mention there was one more decision. I mean, there are several more decisions, but there's another decision that concerns the CCF decision concerns the role of extradition refusals, in which CCF literally relies on a decision not to extradite, national court's decision not to extradite, and goes point by point, examining every element, virtually every piece of evidence that the same country that requested the individual's extradition and then extradition was denied, now litigates before CCF and basically produces CCF with the same evidence that it produced during the extradition trial. And CCF takes this decision, court's decision not to extradite, again goes point by point, because the government produced exactly the same evidence, almost exactly the same evidence, almost exactly the same arguments, and literally in fact, based on that decision not to extradite, makes its own decision not to remove data from Interpol's file. So basically, it seems like that this national court's decision not to extradite was the main piece of evidence, if practically not the only piece of evidence that was enough for the commission to delete the whatever it was, red notice or diffusion from the database.
Perhaps a last comment, Yuri. Yeah, the CCF always says, well, it's not up to the CCF to investigate the case, etc., etc. But where the court has investigated the case, as was the case, they will give great weight to that. Yeah.
Right, exactly. And I mean, it's also this standard that it's not up to them to examine evidence as the national court would do is a little bit vague. I mean, they still take into consideration, some evidence. They just render a decision based on Interpol's rules rather than extradition treaty or the merits of the case as a national court would do. But obviously, we submit evidence to prove that, for example, the charges are baseless, just based on the provisions of the rules on data processing. So we've been live for now over an hour and a half. We'll have to wrap it up, unfortunately. Seems like the software that we're using allows us to stream several social media channels at the same time. Doesn't allow us to share files, but if you want a copy of the presentations that we figures today, feel free to email me. I'll happily share them with their consent, of course, if they allow me to do so. And we will continue covering CCF decisions. There are, again, over 60 of them. And hopefully we will continue to discuss these issues. You can send questions after this webinar, and we'll try and answer them during our future webinars. And definitely look for future announcements on LinkedIn. We will have another webinar next month. Thank you again to my co-panelists today. It was great with a wonderful discussion, and we'll see you soon again. Goodbye.
Thanks, Yuri. Bye, everyone. Have a great evening and a good week.
Thank you.
Bye, everyone. Thank you.
Bye, guys.